well. So up next, we're going to move right into it. We have Charles Vidich here, who was working on this report about this last year on riparian corridor protections. I believe it was sent out to everybody, but if you can't find it, it's on our website too, under our regional planning page. I can send a link out as well so you can have a look at it. It's called the Case for Riparian Corridor Protections. And it was to basically address a lot of the new changes in Public Act 21-29 in regard to contaminants in Long Island Sound. That changed over the summer. So Charles, I'm going to start the presentation for you and you can take it away.
Okay, thanks, Kristen. I appreciate your help on pushing the slides through, and also the opportunity to talk about a study we've worked on for the last 2 years. And by coincidence, Public Act 21-29 made it highly relevant. So you can go to the next slide. Really, the focus of the presentation is going to be on what municipalities can do to improve water quality that discharges into Long Island Sound. And I think it's important to understand that all the rivers and streams in Connecticut, even if they detour through Rhode Island or Massachusetts, all end up in Long Island Sound. So we'll focus in on that issue, as well as the benefits of riparian corridors and some of the history of riparian corridors in Connecticut. One of the things I want to mention, this presentation is different than the one that Kristen and I gave to the Yukon Clear program. We've added a few things that are more specific to land use planners in this particular presentation. That slide, Kristen, I think, if you want to move it over to the, let's try moving it right
Sorry.
up to.
There's something going on with that. I got to figure out what's. Never had that happen before.
It's got a mind of its own, I think. That's what it is.
Okay, let's try that again. And I'll just do this. Can you see it full screen?
Yeah, I can see that. And then you can go to the next slide, I guess. Okay, yep, in the agenda we've just gone over, we will go over some of the key issues at the end about zoning strategies and some summary remarks about how this fits into a strategy for zoning commissions. You can go to the next slide. Okay, there we go. Really, the key point here is riparian corridors provide a whole range of ecosystem services. As you heard from Mike and Tucker, having riparian corridors actually helps with the issues of severe flooding that we experience in Western Connecticut, particularly with hurricanes and large intense storms. But there's a whole variety of other services that are provided, including riparian corridors provide migratory pathways for terrestrial and aquatic species. They support the attenuation of thermal pollution in the river systems when there are tree canopies. And even a more recent study from Princeton University researchers shows that the larger the unfragmented tree canopies, the greater it triggers cloud cover benefits because of the evapotranspiration benefits that are provided by large swaths of forest canopy. So of course, the ultimate goal here is dealing with the aquatic health of Long Island Sound. And you can go on to the next slide. The key to this slide is that dealing with water quality is not simply a matter of dealing with land use. The stormwater management program that exists, that all municipalities in our region need to participate in with the municipal separate stormwater sewer systems, is an important and integral part of reducing stormwater quality or pollution in our river systems. But the non-point source issues have really been best dealt with by Public Act 21-29, which we'll get into, that really mandates all zoning commissions to address land use practices that influence the hypoxic conditions, which is the lack of oxygen in Long Island Sound, as well as other contaminant issues. So we'll go to the next slide here. The whole point of what we're looking at here is that stormwater management programs are of limited value when it comes to non-point sources of pollution, and particularly what we're talking about are fertilizers and pesticides, and as well as leaking septic systems, which are a major problem in America and as well as in Connecticut. Failing septic systems are one of the great contributors to the hypoxic conditions in our river systems. And it's largely because, and you'll find shortly, because some of the standards that we have in Connecticut are not addressing the real issue. You can go on to the next slide. One aspect of this is that we've developed and overdeveloped along our riparian corridors. If you notice, the dark red colors are really along the I-91, I-95, Route 7 and Route 8 corridors, where we have the highest amount of development in the 300-foot buffer zones within the state. The Yukon Clear program put this together. So the dark red is 51 to 71% development of that 300-foot buffer zone. Very large buffer zone, but that's what they chose to do. It gives you a sense of where we have the greatest concern with nutrient enrichment issues caused by overdevelopment. You can go to the next slide. Interesting, following up on Tucker and Mike's work, we have an enormous amount of flood insurance losses in our region. And as you can see, with the exception of Danbury, all of the municipalities that have had great losses, and I'm talking here 15 million or more over the last 35 years, are all in our coastal municipalities. And it's a fairly obvious thing, you know, all water goes downhill and flood intensities grow as you go downstream, and obviously also water quality degrades as you go downstream. You can go to the next slide. Unlike the presentation we did for Yukon Clear,
Charlie, you're muted. We're muted too.
okay, yep, by accident, I hope. Anyway, the takeaway here is that septic systems fail to an enormous degree. In fact, there's on average, EPA has said it's about 20% of all, 10 to 20% of all septic systems fail. But in reality, there are many states in which the standard of failure is found to be at least 50%. So it's an enormous problem. The specific thing of concern here, though, is that the Connecticut Public Health Code is the least restrictive of all the Northeast area states. As you see, it's only a 50-foot setback for a leaching field from a watercourse. Whereas with the, of course, Massachusetts has that, but all the rest of New England, New Jersey, and New York have set standards which are actually much more rigorous and are based on the size of the stream or the gallons per day discharged from a sewage septic system leaching field to determine how far they should be separated. So one of our big problems is not just land use, but it's the state of our public health code. You can go on to the next slide. And of course, two aspects to the issue is one, within the control of planning and zoning commissions, is rethinking what should go in the 100-year floodplain. With the exception of Stamford, which only allows a septic system leaching field in the 500-year floodplain, but not the 100-year floodplain, all of the rest of our municipalities allow them in the 100-year floodplain. And of course, that same issue arises with community sewage systems as well. So a take home is that is something that needs to be looked at. And of course, that what falls within the municipality's broader role, not necessarily zoning, is establishing clean out standards for septic systems 3 to 5 years. There are a number of municipalities in Connecticut have done that. We're faced with serious water degradation issues along their riparian, the riverine systems. You can go to the next slide. The take home of this is on the left side is impervious surface area going from 0 to 100%. And stream quality is going from left to right on the x-axis. When we get to a 65% or more of a watershed being impervious cover, you can basically accept having a 100-year flood occurring annually. So that's a wake-up call for all municipalities in the nation to deal with the issue of how much impervious cover can we handle. But a degradation of water quality happens, as you all know, much earlier, more like 10, 11, 12%, and there anything greater than that. You can go to the next slide. Now, in Connecticut, the Connecticut Deep has established restoration zones and protection zones. And as you can see, we have 4 protection zones, or excuse me, yeah, we have 4 protection zones in the actual, I guess, statewide that have been prioritized for action. And there are 9 river systems that are really of critical concern. But in our region, the Norwalk, the Silvermine, the Saugatuck, and the Still Rivers are prioritized for restoration. So while every municipality has a role in protecting water quality, certain municipalities are going to have a greater responsibility. You can go to the next slide. Just an historical perspective, we've had nearly a dozen river commissions in Connecticut going back to 1971 in our region. Norwalk and Darien were the first to establish a river commission. But most of these river commissions occurred before the explosion in scientific knowledge on the water quality benefits of riparian corridors. That knowledge really came in from the 1990s onward, and it's really become indisputable the value of riparian corridors for water quality protection. So those early commissions really didn't address those issues in any scientific way, but they did do quite a good deal of work in terms of flood storage, protections, and other economic and recreational values. You can go on to the next slide. In the history, of course, the Connecticut Department of Environmental Protection was given a mandate back in 1984 with Public Act 522 to establish a statewide river policy and protect river corridors, and of course, developing river management plans. But the important takeaway here is that while they have that authority, they have no land use authority in a broad sense in terms of land use controls, which would be associated with a zoning commission. So for all the good work they've done, it's only recently that the powers have been given to zoning commissions to play a more active role in river management. So you can go to the next slide. In the overall scheme of things, what's going on right now is that the state of Connecticut has been under an EPA compliance order to address the high phosphorus levels we have throughout the state. And of course, the state legislature mandated in 2012 the new Connecticut Energy and Environmental Protection, now called DEEP, of course, to do something about it. And of course, they came out with the reduction strategy in 2017, which laid out the severity of our problem. And let's take a look at that in the next slide. This is the state of the art of phosphorus yield in Connecticut based on the modeling that DEEP has done. And as you can see, the light green color, which is called the very high 75th percentile level of phosphorus yield, is basically, in many ways, almost identical to the clear diagram that showed on I-91, I-95, Route 7, and Route 8. It's not entirely that, but you can see that the urbanized areas of the state are the most significantly impacted. Yes, we do have low phosphorus yields in the very northeast, which is actually one of the protected watersheds in Connecticut now, effective as of about a month and a half ago. But the whole point here is, while some are have less of a challenge, there's a number of our municipalities that are significantly impacted by phosphorus. You can go to the next slide. You know, not that you don't know it, but both the inland wetland agencies and planning and zoning commissions play a role in corridor protection and corridor practices. I took the time to look at the upland review areas and also look at the riparian corridor setback standards that exist across the state. Upland review areas, as you know, are only regulated areas. They're not protected areas. In contrast, planning and zoning commissions have the authority to establish protected areas because they have the authority of setback. They have the authority to actually avoid case-by-case analysis. They can establish standards, and that's what uniquely makes them a much more powerful organization to deal with the issues of riparian corridors and water quality degradation issues. You can go to the next slide. Now, I'm sure all of you would think of upland review areas as dealing with wetlands and watercourses. And as you can see at the bottom of this slide, virtually every town in Connecticut has an upland review area for wetlands and watercourses. But more importantly, there's at least 16 other, exactly 16 other upland review area criteria. And it shows you the variety of things going on in Connecticut dealing with the protection of water, but they're what I'd call one-offs. They're not statewide strategies because we do not have, as you'll see shortly, a statewide policy or regulation that sets a setback for upland review areas. These are all locally decided based on recommendations of DEEP. Used to be DEP when they made them. So let's look at the next slide so you can see what this looks like. While 114 of the 169 towns have the 100-foot setback, we have 20 that have lesser setbacks and 29 that have larger setbacks, and of course 5 towns that have no upland review areas, I should say. So that's an interesting situation given what goes on in the rest of New England, which we'll get to. You can go to the next slide. Here's a view of it. What you'll see here is that 15 of our 18 towns have actually established 100-foot or more upland review areas, and we have 3 municipalities that have lesser standards. But as you can see, there's the variation of where these higher standards of performance are mostly in the northwest, northeast areas of the state, with some exceptions, of course, like the areas of Hamden and Wallingford. You can go to the next slide. Now let's talk about what we found in Connecticut. There's various types of riparian corridor concepts. There's the comprehensive ones, which we call ecological planning or maintaining flood storage on this first of 2 slides. And then there are the one-offs where people just say, well, you know what? I don't think I want a cemetery next to the river, or I don't want a parking facility next to the river. Those are the one-offs of which we have numerous examples around Connecticut, but the comprehensive approaches are much more limited. In the case of riparian setbacks, which is a really pre-FEMA strategy that exists in a number of towns in central Connecticut and northwest Connecticut. We only have 9 towns that do that with various setback standards on average shown on the right. Ecological planning, we have 5 municipalities that have done that strategy, and they've had much more comprehensive setbacks. You can go to the next slide. What we do have, of course, are 2 other categories, or the comprehensive approach for riparian setbacks, or we're 30 municipalities. Those are the leading edge progressive riparian corridor protectors of our state. And then, of course, we have the one-offs again, but are focused on reducing pollutant loadings for particular chemicals, organic materials, salts, and what have you, And these are ones where they're doing something, but it's only based on a single item that probably came up at a planning and zoning commission, which they didn't like and decided it was time to regulate it, as opposed to a comprehensive approach, which these 30 municipalities have taken. We'll show you shortly. You can go to the next slide. So basically, the two broad types are the water resource-based riparian corridors that are the towns in green, and then those who have based riparian corridor concepts largely on the flood storage concept or protection of activities within a flood storage zone. And the towns that are basically where, if you know where the Salmon River, the 8 Mile River is, which is really along the coastal towns on the southeast there, those are really the leading edge municipalities when it comes to riparian corridor protections. The ones that actually, I believe at our point now, are going to be the models for the rest of the state. You can go to the next slide. Now, you can put your seatbelt on for this one, just so you don't fall off your chair. But if you look at all 6 municipalities here, I think you'll notice that Connecticut is the only state that has no minimum stream setback or river setback set by law or regulation. All of it is being done by local inland wetland agencies or by zoning commissions. In contrast, the rest of New England has standards that are not only far beyond what this DEP is doing, but far greater on average than what any of our municipalities are doing. In fact, these are only the stream and river setbacks. They have numerous other setback standards for critical habitat areas, as well as water supply reservoirs areas. They have a whole host of things which might exist as a one-off in 1 or 2 towns in Connecticut. So we really have a completely different structure here in which the other states have actually mandated these things, or in some cases like Rhode Island, they've completely eliminated local control over the riparian corridors, and they've taken over that, at least since 2015, taking this as a very serious issue. All of this reflects what's happened with the science of riparian corridors, which has been really captured the imagination of the rest of New England. And of course, the way they establish a stream standard may vary by channel width or watershed size, but these are the numbers that apply. The footnotes are below that give the detail of how they apply these standards. You can go to the next slide. Now, this is really one of the classic studies, one of the ones that's been referred to, because the Chesapeake Bay is really the bellwether spot for riparian corridor research in America. Really, at least from the point of urban areas, that's because it's in the backyard of EPA's headquarters, and it's really done some great work. And as you can see this, if you look at column 3, the width of a buffer zone, a 15-foot buffer zone of grass compared to the bottom line of a 93-foot grass and forest one zone, you're dealing with on sediment an increased efficiency going from 61% on a 15-foot buffer to 97% for sediment load reduction. And similarly for nitrogen, phosphorus, going from a 28% reduction for a 15-foot buffer to a 77% reduction for a 93% buffer. And that's one of the reasons why the Chesapeake Bay recommendations now are to go to a 150-foot buffer, which are really comparable to what is going on in the rest of New England. And of course, we do have a few municipalities that have come to that realization in the Upland review area and in some zoning strategies. You can go to the next slide. Of course, sediment removal and nitrogen removal are not the only reasons for riparian buffers and their purposes. Wildlife habitat, water temperature moderation, bank stabilization, all play a role. And you see in this slide, the range of buffer standards that can exist. Not only do they vary by those who adopt them, but they also vary by the degree to which one is trying to apply those for certain wildlife habitats. Not all wildlife requires the same degree of buffer zones for, let's say, terrestrial and aquatic species migration. I also will mention that buffer zones are also going back to the days of Frederick Law Olmsted, who basically recognized the importance of river corridors as part of the protection of our urban systems. And he did work that was remarkable in a number of cities in protecting riparian corridors for recreational purposes. And of course, that's in a different standard, not based on the science issues of nitrogen removal, but it's part of the legacy of planning in America, since he's one of the first environmental planners in our nation. So you can go to the next slide. Now let's talk about the key issue of 2129, that law. The word shall appears in Public Act 2129 in the context of a municipality that is contiguous to, and here's the key new phrase, on a navigable waterway draining to Long Island Sound. Those underlined words are what were added. And basically Part A and Part B, which has to do with the restoration of Long Island Sound and reducing pathogens, hypoxia, and toxic contaminants, are the two criteria that apply to all municipalities now in Connecticut, not just the coastal towns. And item C is really something only relevant to the coastal towns, but it is part of what that law established. You can go on to the next slide. Now, how do we know water drains to Long Island Sound? Well, first of all, there's the legal question of, well, even if it does, what if it doesn't apply to us? Well, that has already been answered by the US Supreme Court in 2020 ruling by EPA. Basically, as long as the water that is coming from the so-called navigable waters upstream, up gradient, is hydrologically connected to downstream river systems, then there is a nexus with the pollution that's caused in Long Island Sound. And this basic decision in the Rapanos case of 2006 before the US Supreme Court makes it very clear that the responsibility for cleaning up Long Island Sound rests not with the coastal municipalities, but it actually rests legally with every municipality in the state of Connecticut. And actually, to take it a little further, New Hampshire, Vermont are also responsible because they discharge into the Connecticut River. And also, in the Housatonic, it goes through Massachusetts. So it is not just Connecticut that's on the hook. The entire New England, New Hampshire, Vermont, and Massachusetts have a compliance responsibility in this regard. Indeed, much of the pollution that we're facing in Long Island Sound comes from, according to the Geological Survey studies, about half of it comes from above the border of Connecticut. So that still doesn't get us off the hook, because no matter how much we point to someone else, EPA is still holding us responsible for that share of it, which is ours. So you can go to the next slide. So 3 strategies we've developed, all within the final report in the appendix. They're all complementary in their approach. Watershed management protections, which is a watershed management regulation following the Guilford, Connecticut strategy for a surface water supply protection system. And then there's a riparian corridor protections, which mimic the watershed management protections, but include other items such as minimum setbacks from rivers and tree canopy considerations. And of course, the third item, which is really project-based, which you're all familiar with, is low impact development. All 3 are a gestalt. All 3 go together to be the most comprehensive approach. But if we're looking at one thing that works best, that's right to the kernel of the issue, it would be the riparian corridor protections, because that's the most direct buffer to the pollution which is being discharged into our river systems. So you can go to the next slide. Basically, the take home here is there really, there are urban approaches, there's suburban approaches, and there's rural approaches. The incentive approach is what you might take on in a Stamford or Norwalk, where you incentivize people to create pervious cover or to create tree canopies where they don't exist. Whereas if you're in the suburban areas, you're going to deal with really the recommended approach is an overlay zone approach where you deal with chemical management, setbacks, land cover, ecosystem service principles as criteria to include in the riparian corridor. Not all of those may be used in any given case, but those are the principles behind it. Now, if you take the simplest approach where you're in a very rural area, you may just be able to deal with this issue as a setback-based concept. And all of those concepts are in our final report as examples of what could be done within our region. You can go to the next slide. So this is just the conclusion. There's 4 elements. There's the scientific evidence that we've talked about with pollution attenuation and flood mitigation issues. Then there's the legal mandate, which is Public Act 2129. But I think it's also important to understand that that's only the most recent one. We also had back in 2004, the act which gave much more restrictive flood storage controls to municipalities than the FEMA standard, which is a very valuable tool. And of course, since 1985, our municipalities throughout the state have been able to protect surface water from degradation with the broad umbrella enabling provisions that were made back in that Public Act 279. And of course, the third point is not only did we have a legal mandate, but the case law supports the navigable water principle here, that if you create pollution and it goes downstream, you're responsible for that pollution. And of course, the one thing I think everyone should know, that this law is very different than other laws that have ever been through zoning, because it creates equitable relief under Public Act 7196, which was the public trust remedy law, which is established at the same time as the Connecticut Department of Environmental Protection, which basically means that any person can seek remedy for the unreasonable pollution of our water and natural resources by suing a planning and zoning commission for failing to undertake the mandate that has been established here. I say this because this has been brought up to me by the Council of Environmental Quality chairperson, who made that point at a recent meeting, that this is what singles this particular law out differently from others that affect planning and zoning commissions. So that concludes my presentation. And I think just the last slide is just to remind people that, we have both all of the model regulations in that final report on our website. So that will do it.
Great. Thank you so much, Charles. That was a very comprehensive analysis. And if anyone has any questions, you can please feel free to unmute yourself and ask them. I will share a link to the report in the chat too, if it's not already in there. Let's see. Nope. Okay, I will send it right now. Are there any questions for Charles?
Yes, I have a question. This is Todd Fontanella at WestCOG. Charlie, the question I have is why were the laws restricted to tributaries of navigable waterways? I was curious as to why it was limited to that.
Why was the law limited to the draining the navigable waterways? Was that your question?
Yes. Mm-hmm.
Well, I can't tell you who actually inserted that language, but the navigable waterways is a term of law that has been established by US EPA and the Army Corps of Engineers. And basically it is responsible for all waters of the United States. The issue has been litigated a great deal as to what that encompasses. EPA would like to make it cover all waters of the United States. There was a point in time when a little puddle that a duck could land in was considered the waters of the United States many years ago, until that was overthrown. So the focus really of what has been done by the Connecticut legislature is to use the word navigable waters, because that is the term of art which the state of Connecticut must comply with. We have a federal servitude insofar as we're must comply with federal clean water laws. And that's where that term comes from. The Clean Water Act drives this. And as a result, EPA's definition of navigable waters becomes the broadest term possible, as opposed to actually using a term like river or tributary or stream, which are really actually not legal terms. They're just more, I guess you could say, descriptive terms, but not legal terms.
Thank you.
Yeah, it'll be interesting to see where this goes. It will take some thought, I believe, for municipalities to do this. And I don't believe all municipalities are going to come up with the same strategies, nor should they, because of the differences in the urban development in some areas and lack of development in others, and the level of impervious cover. And I think, I do know that Norwalk is working on strategies which are very, I think, right up the right perspective on this, which is to be looking at incentives that will create green spaces, which in turn are really complementary to riparian corridors when they're related to riparian corridors anyway.
Charlie, do you think the state, would it be helpful for the state to establish some minimum standards for tributaries statewide that municipalities could exceed? Because obviously we're quite different from other New England and Northeastern states in this.
I definitely believe we should be following what the other New England states are doing. The problem we're facing is that our Connecticut Department of Energy and Environmental Protection is the least well staffed and the least well budgeted, and it's hemorrhaging staff at this point in time. And so while I believe that a statewide standard rather than a recommendation would be ideal, the challenge is going to be the only way that could work is if it's done a little bit like what Maine has done, where they created a statewide standard and mandated that every municipality must follow that standard. Now, if it's done that way, I think we could achieve it, because using the Maine strategy, it's basically a statewide standard, but it's willy-nilly must be implemented by every municipality in the state of Maine. So that would be the way to do it, because our DEP they don't have the budget or the staff to actually do it. But I think that the Maine approach could be the way to do it. And by that, I mean the state of Maine.
Any other questions for Charles? Okay, so hearing none, I'm just going to